For the past few days, Facebook has been announcing that I would make pertinent political statement to this medium today. This, of course, has been as a result of the need to keep our citizens informed on very critical issues that are arising on a daily basis in St Kitts and Nevis. We also, of course, want to use this medium to present to the public our policies, our programs, our projects that will be pursued by the next Gen SKN Labour administration that is incoming and will be with us in the early part of next year. Today I am speaking on a particular issue that has emerged and has somewhat, to a large extent, called for immediate response on the part of the party, as very many people are asking us for our comments. And so I wish today to speak on the matter of the recent judgment against Lindsay and Jonel Powell. If you were to look at the Eastern Caribbean Supreme Court judgments on the internet, I make reference to the Eastern Caribbean Supreme Court in the High Court of Justice in the Federation of St Kitts and Nevis and in the St. Christopher Circuit, the matter between Tanzania, Tobin, Denzil as claimant and respondent, and Lindsay F.P. Grant and Jonel F.H. Powell as defendants and applicants. This judgment being delivered I should say, as a result of hearings on the September the 26th, 2019 and October the 28th, 2019. I know both of these gentlemen, one being a Minister of Government, Minister of Tourism and Trade, International Trade to be exact. Other as a young man who has been appointed Ambassador at Large and advisor to the Harris government in the Ministry of Culture and also, I think, in the Ministry of Sports and Youth. I have nothing personal against any of them. In fact, I believe, however, that in my own capacity as the leader of Her Majesty's opposition, as a member of Parliament, as the leader of the St Kitts and Nevis Labour Party, which is the predominant party in St Kitts and Nevis, and as a private citizen, I wish to make known and to help to educate the general public on the issues arising from this particular matter. And so I will spend some time going through the judgment, utilizing this particular medium to educate and to inform, so that when the discussions and the debates and the comments on this matter would arise in the future, people would be doing so from an informed position and not out of emotions and otherwise. On the 20th day of October 2019, the High Court of Justice dismissed an application brought by Grant and Powell seeking an order to set aside a default judgment obtained by a client of theirs. Default judgment means that the case was heard in our court and the defendants were not there to put forward their defense for whatever reason, and the court proceeded with the trial and gave judgment on the matter. According to the judgment, especially in paragraphs 1 and 2, on the 22nd day of December 2017, the claimant, who was an applicant for economic citizenship, filed a claim against Grant and Powell for, among other things, breach of fiduciary duty and trust as his solicitors, misappropriation of client funds, that is, illegally using the client's funds in the sum of $450,000 US dollars, and for damages caused by their failure to pay out the purchase price entrusted to them as his solicitors. The sum of $450,000 US dollars was entrusted to them, that is, Grant and Powell and the firm, as solicitors since May of 2013. May of 2013, several years ago. Grant and Powell failed to file a defense to this claim within the time required, and so on the 9th of October 2018, judgment in default was entered against Grant and Powell on terms to be determined, and that is found in paragraph 5 of the judgment. On the 16th day of October 2018, Grant and Powell applied to have the default judgment against them for breach of duties as a solicitor and for misappropriation or the illegal use of funds set aside, and this is found in paragraph 6 of the judgment. In order to set aside the judgment, Grant and Powell had to satisfy the court of 3 basic but important requirements. If they fail to satisfy any one of these 3 basic but significant requirements, the judge will not be able to set aside the judgment. What are these basic requirements? 1, they had to apply promptly to the court with regard to the default judgment against them. 2, they have to have a good explanation for not filing a defense in time. And thirdly, they must have a realistic prospect of defending the claim. In the alternative, there must be exceptional circumstances which allow the court to set aside the default judgment. All this is found in paragraph 7 of the judgment. What did the court find? While the court found that they applied promptly, they failed to provide a good reason for not filing a defense, and more importantly, the draft defense they intended to file had no realistic prospect of success. In other words, they did not have a defense to the claim for breach of duty as solicitors and for misappropriation or the illegal use of the client's funds. All this is found in paragraph 23, 26, and 27 of the judgment. What was their defense, in fact? According to paragraph 26 of the judgment, the essence of the defense is that, 1, they have been actively trying to pay over the funds to the vendor and the claimant. 2, but while there was a delay in the completion of the transaction, 3, all the delays were resolved, and the claimant was put now into a position to close the transaction prior to the filing of the claim. Now, this defense was not accepted by the court as a defense with any realistic prospect of success in the court. If monies were paid over in May of 2013 and in December 2017, the client is suing you for the failure to pay out the funds, failure to account, and breach of duties. This delay could not be a slight delay. The court found that this is a very, very long and unacceptable delay. At paragraph 27 of the judgment, the court said that, and I want to quote here, the defendants have in fact shown no prospect at all, since they have not fully answered the specific claims of the claimant in respect of 1, breach of trust, 2, breach of fiduciary duty, 3, failing to account or misappropriation or the illegal use of monies belonging to the claimant, their client. End of quote. At paragraph 28 of the judgment, the court said that Grant and Powell failed to establish 2 of the 3 basic but significant requirements to have the default judgment set aside, and therefore they were not entitled to have the judgment set aside. This means that, contrary to what Grant and Powell have said to the public in recent times, there is a judgment, and I repeat that, there is a judgment against them on a claim of breach of duties as solicitors and escrow agents, and for misappropriation or the illegal use of their clients' funds. In fact, at paragraph 27, the court said on the 11th day of February 2019, it ordered damages to the claimant to be assessed. And of course, by the judgment dated the 28th day of October, most recently, in 2019, of course, the court in the final paragraph gave directions for assessment of damages against Grant and Powell and in favor of their former client, the claimant, who had taken them to court. There are therefore 3 judgments, not 1, not 2, but 3 judgments in this matter against them, against Grant and Powell. One dated the 9th of October 2018, a second one dated the 11th of February 2019, and the third judgment dated the 28th of October 2019. There is also an upcoming judgment against them once the assessment of damages is heard by the court and decided upon. Again, I want to make the point as I made at the beginning. I am not here to judge anyone. The court has already passed several judgments, in fact, 3 judgments. But as the leader of Her Majesty's opposition in the Federal Parliament of St Kitts and Nevis, and I being a member of Parliament myself for my constituency, and as a member, or as I should say, the leader of the St Kitts and Nevis Labour Party, and as a citizen of our beloved country, which is run by a democratic government along the principles of democracy, it is my duty to help to educate our citizens on this particular matter. Educate in order that we can better understand, so that as our people debate this particular matter, and as our citizens at home and abroad talk about this breach of trust, this misappropriation or the illegal use of clients' funds by these 2 lawyers, that they will be able to do so from an informed position to better understand the issues that are relevant here. Remember that this government was elected on a good governance agenda. And so what are some of these issues? 1, the issue of trust, which of course will prompt us to ask the question, can you really trust these 2 gentlemen? The question, you may think, is premature, but there are 3 judgments which have raised the question of trust and heard in the court. And the court has already decided that there has been a breach of trust with regard to these 2 gentlemen handling the affairs of this client, their own client. Money to the tune of almost $500,000 that it would appear the court has said has been misused. And so the issue of misappropriation of funds also arises. Is it right for any lawyer, anyone at all, to misappropriate funds that belong to someone else? Is it right for persons to use funds illegally, funds which had been entrusted to them for a particular purpose, and use otherwise? The issue of misappropriation or illegal use of funds, that issue arises. Is not this a relevant issue to be considered in the future? The issue of the effect of their action on our CBI program, or Citizenship by Investment program. Recall that the client was interested in becoming a citizen of St Kitts and Nevis. was purchasing a property that was close to $500,000 US. And these funds, it would appear, according to the judgment of the court, were misappropriated by this law firm of Grant and Powell. In fact, how this will affect, that is, this judgment, that says that lawyers who are engaged as service providers in the citizenship by investment program in St Kitts and Nevis are misappropriating their clients' funds. How does this really affect our program to those abroad when they would have become familiar with this judgment? Would they have confidence in our program? And we say at this time that this program has been severely affected by this present administration. Isn't this a worsening of that negative effect that we say is being experienced by this government utilizing this program to advance the economic development of St Kitts and Nevis? Another issue that arises is the issue of the Harris administration being a scandal-ridden administration. Scandal after scandal after scandal has been arising over the last 4.5 to 5 years. The scandal of the unethical and the illegal stem cell clinical application that took place in our own Joseph and France General Hospital without the consent of the chief medical officer and others. The government promised that it would investigate this matter and bring the results of the investigation to the general public. To date, we have heard nothing whatsoever coming from the government with regard to this particular scandal of the unethical and illegal stem cell clinical application to patients performed by doctors who were from outside, came into our country, were not properly registered by the medical board, yet performed surgical interventions in our own hospital on patients here in St Kitts and Nevis. The scandal of the unethical herpes vaccine trials that took place here in our country in a private home, not in a clinic, in a private home in Frigate Bay, St. Kitts, when in fact United States authorities had refused these same practitioners from doing this same thing in the United States of America. But our government allowed them to come into St. Kitts and Nevis and did that, which was again unethical and unknown to the authorities in the Ministry of Health here in St. Kitts and Nevis. It was only after the scandal broke in the United States of America that we were aware that this had actually taken place here in St. Kitts and Nevis. That is why I said the issue of the scandal-riddled administration of Harris. And yet again, the scandal of our own Prime Minister being involved and named in the United Kingdom and is needed in the United Kingdom for questioning on the Peter Verdi bribery case, in which it is claimed that Dr. Harris did in fact asked for fancy shoes, expensive watch, after dinner late night parties, bribery money as part of a bribe to bring investors in the renewable energy sector to our shores in St Kitts and Nevis. And so, my Facebook friends and citizens of St Kitts and Nevis, it is in this context, and in the context of several members being involved in these scandals, that I bring this matter to you today. I believe, therefore, that it is pertinent for the ongoing debate to consider a number of questions. Should the officials named in this judgment, officials of the government that is, should they not resign? Should not at least Lindsay, the Minister of Tourism and the Minister of International Trade, should he not resign his portfolio appointment, given the nature of this matter, given the scathing judgment against him that was held in the court? And not even one judgment, but 3 judgments being brought against him successfully in the court of the Eastern Caribbean Supreme Court. Even though we understand that these 2 gentlemen will either on their own behalf or on behalf of their company appeal these 3 judgments, and the 4th judgment is still to come, even though they are saying that they will appeal, isn't it right? Isn't it ethical that they at least resign until their names are cleared after the appeal is heard? Isn't it right so to do? These are questions that are pertinent to this matter. I believe that there is also the matter with regard to the effect of this on the CBI program. Is this not a matter that can undermine the citizenship program? These 2 gentlemen and their firm, they are service providers, appointed or licensed to operate in the CBI program, licensed by the Financial Services Regulatory Commission. Is it not proper for the Commission to take the necessary action and at least relieve these 2 gentlemen, the firm of Grant and Powell, of their licensing services within the context of the CBI program, when the court, in 3 separate judgments, has found them to have breached their responsibilities, the confidence of their clients, their fiduciary duties, misappropriation or use of their clients' funds, and these relevant with regard to the Commission at least sitting to consider whether they are still fit to be part of this program, to service applicants who want to come into our citizenship program. And so I want to stop here with these questions. Because again, as I said, I point no finger. I am not judging this matter. The matter has been judged. 3 judgments have been passed. A 4th judgment is being awaited. The specific cases involving these 2 gentlemen, we understand, or the specific claims, we understand, will be appealed by these 2 gentlemen. But in the meantime, what? That is the fundamental question I would end with today. My dear Facebook followers, thank you again. And of course, we meet again in the near future. God bless you. Thank you.